With me now to discuss from the Heritage Foundation is Sarah Perry. Thanks for being here tonight, Sarah.
Thanks for having me.
Great. So this decision over standing, which seems boring at first, perhaps to some in the audience, myself included, you might look and go, oh, okay, another one of these cases. But what kind of major implications does this have for the way colleges and universities attempt to stifle speech on campus? So talk to us, I guess, about how this decision could make these institutions think twice before enacting such policies.
So the case is Uzuegbunam versus Preczewski, and this was an 8-1 decision. The opinion was issued by Justice Clarence Thomas, writing for almost a unanimous majority. Unfortunately, Justice Roberts was a holdout. He was a dissent. But in this case, ultimately, it was a question as to what constitutes sufficient level of injury or redressability of an injury. It's one of 3 elements that are required for standing under Article 3 of the Constitution. And these two former college students at Gwinnett State College were trying to exercise their free speech and their religious liberty. They were given the opportunity to speak first after being shut down in a free speech zone, which constituted less than 1% of the college campus total area, and to do so with a permit. Chike Uzuegbunam is the lead petitioner in this case, the namesake of the case, and he achieved the required permit, went to the free speech zone, and then was still shut down after some students complained that he was in violation of the speech code for making other people feel uncomfortable. So what he was doing was exercising his religious liberty. And after the speech code had worked its ill magic on the petitioner, they appealed. They decided they would go to the Supreme Court, and the Supreme Court determined we do not find the minimal level of compensatory damages, the nominal damages. It's hard to quantify these actual damages, and instead we find that even if you tack on $1, if we have a completed legal violation, which the petitioners had here, we find nominal damages to be sufficient to bring suit when the other elements are met.
And so when, as you mentioned, John Roberts strikes again, what did he say in his dissenting argument? Why did he not join the other 8 justices in moving forward with this case?
Well, he took the college's position, which was we can't put a dollar amount on an injury of this nature, and specifically, it's no longer a live legal controversy. In other words, the college had changed their speech policy, and in so doing, what they had done is create a completely different environment. There was no longer an injury that needed addressing by the Supreme Court. To which Justice Thomas replied, even if we would award $1 for lost bus fare traveling to a free speech zone, which we would if the opportunity was shut off, we would award the same dollar, even more so for a constitutional rights violation. The goal, obviously, making sure that our economic rights are not higher esteemed than our constitutional liberties. Those hold a very cherished, legally protected status in America.
And now, where does the case now go from here for these 2 Georgia Gwinnett College students?
So they will remand the case. The Supreme Court remanded the case and sent it back down to the trial court for a determination of whether or not they had their rights violated, specifically Chike's rights. They had made a determination on the merits, but we were only considering the Supreme Court level, whether or not we were sufficiently arguing the level of damages pleaded. In other words, did we meet the standing? The merits claim itself was a separate question altogether, though we don't have any concern about the fact that any judge who is looking honestly and the attorneys themselves will determine at this point the case will go forward on the merits for both of the petitioners. So it's a good outcome overall, and it will prevent aggressive campus speech policies in the future. So though it looks like a short opinion, which it is, 10 pages, and it seems to be a simple procedural question, it actually has very broad implications for the protection of First Amendment rights on college campuses.
I'm very happy to hear this. We really do need one of these pick-me-ups, especially with everything going on in the news cycle right now. But Sarah, thank you so much for joining us tonight.
Thanks for having me.
Thanks for watching the Heritage Foundation's YouTube channel. With more than 500,000 members, we are the nation's largest conservative research and education institution. We believe the principles and ideas of the American founding are worth conserving and renewing. Please help us further our mission by subscribing to this channel and sharing our videos with your family and friends.